Bringing your family together is a journey of patience, precision, and above all, hope. If you are watching this video today, you may be a United States citizen or a lawful permanent resident who has filed or is preparing to file a petition to bring your spouse, your child, your parent, or your sibling to live with you in America. And if you have been following the news in February of 2026, you may have heard whispers about new DNA testing requirements, about priority shifts at USCIS, about delays at embassies, and perhaps you have felt a twinge of worry. My goal today is to explain how these 2026 updates actually protect the integrity of your family's petition, and to give you the tools to navigate this process with confidence and clarity. Before we begin, I want to offer a brief but important disclaimer. The information I am sharing with you today is educational in nature. It is not legal advice tailored to your specific situation. Immigration law is complex, and each family's circumstances are unique. If you are in the middle of a petition, or if you are facing a difficult decision, I encourage you to consult with a licensed immigration attorney who can review your documents and your timeline. This video is designed to inform you, to empower you, and to help you ask the right questions when you sit down with your legal counsel. Now, let us talk about what is happening in February of 2026. The Department of State has just published the latest visa bulletin, and for many families the numbers have moved forward. This is good news. But at the same time, USCIS has announced a reprioritization of how it processes Form I-130 petitions. What does that mean? It means that the agency is now directing more resources toward clearing the backlog of immediate relative petitions. These are the petitions filed by U.S. citizens for their spouses, their unmarried children under the age of 21, and their parents. The law considers these relationships to be the most fundamental, and so USCIS is giving them top priority. This is a humane and sensible policy, but it does create a ripple effect. If you are in the F2A category, meaning you are a green card holder petitioning for your spouse or unmarried child under 21, or if you are in the F2B category, petitioning for an unmarried adult son or daughter, you may notice that your case is moving more slowly than it did in late 2025. This is not because your petition is any less important. It is simply a matter of agency capacity. The law has not changed. Your petition is still valid, but the processing time may stretch a bit longer. I want you to understand this so that you do not panic if you see your receipt notice sit for several months without movement. Let me now turn to one of the most critical topics for families with children, and that is the Child Status Protection Act, known as CCPA. If you have a son or daughter who is approaching the age of 21, you need to listen very carefully to this section. The CCPA is a shield. It was created by Congress to prevent children from aging out of their immigration eligibility simply because the government took too long to process their parents' petition. Here is how it works. When USCIS approves your I-130 petition, the National Visa Center will send you a notice with a priority date. That priority date is the day USCIS received your petition. Now, when your priority date becomes current, meaning the visa bulletin says that visas are available for your category and your country, your child's age is not simply their biological age. Instead, you calculate what we call the CSP age. You take your child's age on the date, the priority date becomes current, and you subtract the number of days that the I-130 petition was pending with USCIS. The result is the CSPA age. If that number is under 21, your child is protected. But here is the crucial part. In February of 2026, the Visa Bulletin has two charts. One is called Final Action Dates, and the other is called Dates for Filing. USCIS has announced that for this month, families may use the Dates for Filing chart to submit their I-485 applications for adjustment of status if they are already in the United States. Why does this matter? Because the moment you file the I-485 while the Dates for Filing chart shows your priority date as current, you freeze your child's age for CSPA purposes. Even if it takes USCIS another year to actually adjudicate the I-485, your child will not age out during that waiting period. This is why timing is everything. If your child is 19 or 20 years old, and your priority date is close to becoming current, you must be ready to file the I-485 the instant the Dates for Filing chart opens up. Do not wait. Do not assume you have extra months. The age-out trap is real, and it has broken the hearts of many families who missed their window by just a few weeks. Now let us discuss the biometric expansion that has caused so much concern. In 2026, the Department of Homeland Security has proposed a new rule that would require all individuals associated with a family-based petition to provide expanded biometric data. This includes not only fingerprints, which have been standard for many years, but also iris scans, voice prints, and in some cases DNA samples. And here is what has surprised many people. The rule applies not just to the foreign national who is seeking the visa, but also to the U.S. citizen or green card holder who is sponsoring the petition, and even to children under the age of 14 who are listed as dependents. Why is the government doing this? The stated purpose is to prevent fraud. Immigration fraud, particularly in the family-based category, has become more sophisticated. There have been cases of individuals presenting fake birth certificates, claiming to be siblings or children when no biological relationship exists. There have been cases of couples who never actually lived together as husband and wife but who filed joint petitions anyway. The government believes that by collecting biometric data, including DNA, it can verify relationships with scientific certainty. Now, I understand that this feels invasive. I understand that many of you are asking, why should I, a U.S. citizen, have to give my DNA to the government just to bring my own spouse or child to America? These are valid concerns, and the rule is currently in a public comment period. But if it is finalized, you will need to comply in order to move your petition forward. The practical impact is this. You will receive a notice to appear at a USCIS application support center, and you will be asked to provide these biometric samples. The process is quick, usually under 30 minutes, and the data is stored in a secure government database. It will not be shared with third parties, and it will not be used for purposes unrelated to your immigration case. If you have moral or religious objections, you may be able to request a waiver, but the bar for approval is very high. My advice is to view this as one more step in the bureaucratic process, a step that ultimately strengthens the credibility of your petition. Let me now address a troubling trend that many families are experiencing at U.S. embassies and consulates abroad. Even when an I-130 petition has been approved and a visa interview has been scheduled, many applicants are receiving what is known as a 221G notice. This is a pink slip that says the application is under administrative processing. The consular officer does not deny the visa outright, but they do not approve it either. Instead, they ask for additional documents, additional information, or they simply say that the case requires further review. In 2026, the most common reason for a 221G hold is something called online presence vetting. The State Department is now reviewing the social media accounts, the email addresses, the messaging apps, and even the public photos of visa applicants. They are looking for any indication that the applicant has made statements that are inconsistent with their visa application, that they have ties to groups or ideologies that could pose a security concern, or that they have misrepresented their relationship with the petitioner. This process can take weeks, sometimes months. A 221G notice is often just a pause, not a final no. If you or your family member receives this notice, do not panic. Respond to every request promptly. Provide clear, truthful documentation. If the consular officer asks for proof that you and your spouse have maintained a relationship, send them photos, send them chat logs, send them evidence of financial support or visits. The more you can demonstrate the genuine nature of your relationship, the more likely it is that the 221G hold will be lifted. Now let us talk about the public charge rule. This is a topic that creates enormous anxiety, especially for families with modest incomes. Under current law, a U.S. citizen or green card holder who sponsors a family member must demonstrate that they can financially support that person at 125% of the federal poverty guidelines. For a household of 2 people in 2026, that threshold is $25,550 per year. If your income falls below that level, you will need a joint sponsor, someone who is willing to sign an I-864 affidavit of support on behalf of your family member. But here is what many people do not realize. USCIS is now looking at more than just income. They are looking at what they call the totality of circumstances. This means they consider the age, the health, the education, and the job skills of the person you are sponsoring. If your spouse is a trained nurse or an engineer, that works in your favor. If your parent is elderly and requires significant medical care, that could raise concerns, especially if you do not have proof of health insurance. The public charge rule is not designed to exclude poor families. It is designed to ensure that immigrants will not become dependent on government benefits. If you can show a stable income, a history of employment, and a plan for how your family member will integrate into the U.S. economy, you will be in a strong position. Finally, I want to address the difference between a visa pause and the processing of I-130 petitions. Some countries are currently subject to temporary pauses in visa issuance due to diplomatic disputes or security reviews. This does not mean that your I-130 petition will be denied. It simply means that even if USCIS approves your petition, the embassy may not be able to issue the visa until the pause is lifted. This is frustrating, but it is beyond the control of USCIS and beyond the control of your attorney. The petition itself remains valid. When the pause is lifted, your case will resume. In the meantime, ensure that all of your documents are in order. Make sure that your birth certificates, your marriage certificates, and your police clearances meet the exact reciprocity standards published by the State Department for your country. If a document is missing a seal, if it is not translated properly, if it does not include the name of the issuing official, you will receive a request for evidence, and that will delay your case by many more months. Bringing your family together is a journey of patience. The CSPA rules are a shield for your children, if used correctly. The new biometric requirements, while invasive, are part of the government's effort to protect the integrity of the system. A 221G notice is often just a pause, not a final no, and the public charge rule, when understood properly, is not an insurmountable barrier. I want you to know that the law still prioritizes family unity. It still recognizes that the bond between a parent and a child, between a husband and a wife, is sacred. If you have questions, if you are unsure about your timeline, if you are worried about your child's age, I encourage you to seek professional guidance. And I invite you to share your story in the comments below. Tell us how long you have been waiting. Tell us which country your family is coming from. Your voice matters, and together we can navigate this process with dignity and hope.